Hi, I'm Harvey Z. Warren, your drop dead coach. Legal resources and challenges is the name of this module. We would hope that every creditor would have the decency and common sense to work with you based on what you can pay, but sometimes they do not. Many creditors have policies of automatically suing consumers. That's unfortunate, but that's the way it is. In Chapter 10 of my book, I have a section called Damage from Lawsuits and Judgments, the most difficult choice. And this is what I write. Creditors, collection agencies, and debt settlement attorneys have the right to sue you if you don't pay your bills. If you file for bankruptcy, you can get a stay that freezes the suits and protects you from legal action. If you're in a credit counseling program, the creditors will not sue you because you are voluntarily in a program that they are subsidizing. If you are negotiating with your creditors yourself or with the aid of an attorney, it is unlikely that you will be sued unless the persons to whom you owe the money suspect or believe that you are not telling the truth about your hardship or your ability to pay. If you're using the service of a debt settlement company, be warned. An increasing number of creditors sue consumers in those programs as a matter of course. The creditor assumes that you are trying to cheat them if you are in a debt settlement program. I won't comment on whether that is right, wrong, fair, or unfair. It is what it is. As I recommended in Chapter 5 and 8, your best option is to appeal directly to your creditor yourself. If that fails, or if you just can't face the music, your next best choice is to seek legal assistance from an attorney experienced in excessive debt issues. The creditor has the right to sue you at any time once you stop paying your bill. It doesn't need to make any sense to you or your attorney. It's the creditor's right. Lawsuits are therefore something to consider before you choose how to try to get out of debt. There is no statute of limitations on a judgment. Should you lose in court or fail by default, if you fail to respond or fail to appear, a judgment can follow you for the rest of your life, and that kind of damage can be hard to outlive. There's a strategy that can be employed when a creditor is just determined to sue you. Often they sue because they believe the customer will, as I mentioned, just default. What does that mean? That means that you fail to respond to a 30-day notice. The creditor goes to court, goes in front of the judge, and asks the judge for a judgment. They will say to the judge, Harvey Warren failed to respond. He's obviously determined not to pay his bill. We need the court's intervention. We need a judgment so that we can garnish his wages and put a lien on his assets. The creditor has rights in court, and it is their right to do that. Often, unfortunately, creditors count on the fact that you won't show up, and they call you a default judgment customer. These folks should have simply come to court and addressed the judge and told the judge that they simply cannot pay the bill, because a series of events takes place when you appear in your own behalf. You don't even have to hire an attorney. Yeah, that might be a frightening prospect for you to go to court without an attorney, but these are pretty common matters, especially in this economy. There are millions of people seeking relief in court. When you show up in front of the judge, there's a series of things that can be said, that ought to be said, as you work to resolve your debt yourself. I'm going to lay out for you here a series of moves and counter moves that are common in the conversation between you and your creditor when they sue you. The unfortunate reality is most consumers presume that when they get sued by a big bank, that they will automatically lose. That is absolutely not true. The big bank has an agenda to collect the debt. You have rights in state and in federal court to have that debt discharged either in a bankruptcy, Chapter 13 or Chapter 7, as we've discussed previously. So when you walk into the courtroom, you have rights as well. You have the right to explain to the judge that you're trying to make payments to the creditor, but the creditor is making a demand on you that you just cannot comply with. You just don't have the money. A court is a place to find facts. And although there may be no real reason for you to not pay the bill other than the fact that you've got bad money management skills or had a divorce or gone through some other hardship, the simple fact of the matter is that the creditor has a right to demand what you owe them. So a conversation begins about what can we do? Where is the middle, or where is the quote-unquote settlement? If you've done your homework correctly and you've made a budget and you've presented a reasonable offer to your creditor, you would show that to the judge and you would say, look, Your Honor, here I am. I've come to court. I've made this plan. I've asked this creditor to help me. I've got 40 cents to pay them over 36 months. They want 80 cents right now. I can't do that. I have 5 other creditors that I owe money to. It's nonsensical for me to make that plan with this creditor. I should just go file for bankruptcy protection. The judge will look at you and say, well, what do you want to do? And you're going to say, well, I want to pay the bill. I just cannot. I want to work it out. Can I go to mediation? Can I get arbitration? The judge at that point will either say yes or say no. More likely than not, they're going to say yes. At that point, maybe 6 months is going to elapse, depending upon what state you're in, before you get in front of an arbitrator or a mediator. You might find, if you get that grant from the judge, that your creditor is going to become much more cooperative in a hurry, which is a great thing. Because in the end, all you're really doing is saying, this is all that I can pay. Please help me. I just want to pay what I can. If you get in front of the arbitrator and the arbitrator agrees with you, they will return you to the courtroom to the judge, and the arbitrator will recommend that they take your plan. If the arbitrator disagrees with you, creditor gets to come back to court and says, pay me. And then you say the same thing you said before, I cannot. And the creditor says, well, you better, or else I'm going to go get a judgment against you. And you're going to say, well, yeah, I guess you're going to have to do what you're going to do. But first, before you do that, let me explain something to you. This is the move and counter move that you and I are going to be in for the next 2 years. You're going to get a judgment. I'm going to ask for it to be dismissed. We're going to go through that for maybe 6, maybe 12 months. Let's just say you prevail. You're going to go and ask for a garnishment on my wages. I'm going to ask for an exemption if you get that garnishment. That's going to go on for another 6 months. 2 years from today, after we've gone back and forth so many times, I'm going to stand at the front of the bankruptcy court, and the day that you have your opportunity to collect the first dollar from me, I'm going to go bankrupt. So let me recap that for you. In the next 2 years, we're going to go to the court. You're going to sue, get a judgment. I'm going to ask for it to be dismissed. Maybe you'll win. You're going to get a garnishment. You're going to come to my employer. I'm going to ask for an exemption. All that process and all that money is going to be spent on legal fees. And the very day that you're going to collect the first dollar from me, that day, I'm going to go bankrupt. Now, I've asked you nicely, please work with me. Please allow my plan to go through. I'm in a terrible pickle here. I just want to pay my bill. Please help me. They're very clear that what I just said is exactly correct. It is the legal process. It is a matter of your rights to assert that you cannot pay. It's a creditor's right to demand that you do pay. And then it's a matter of whether they're willing to meet you halfway or meet you most of the way. If they do not, the final remedy is in bankruptcy court. The critical first step to this whole process, though, is you must be responsive. If you do get sued, it is very important for you to immediately get in touch with your creditor and appeal to them to please don't do that. And to say these following words, I am not a default judgment customer. I know my rights. I am in the Drop Dead Coach program. I have read a book. I know what I'm doing. If you think I'm going to not show up in court, you're wrong. I'm going to come representing myself, and I'm going to do what I have to do to resist paying you an amount of money that I just cannot afford. So I'm asking you again nicely, please work with me. And it really has to be said just like that, because sometimes creditors just have the notion that you're trying to beat them, that you're trying to give them a haircut, that you're trying to cheat them out of the money that they should be collecting. And they're going to give you some pretty hard shaking before they decide, okay, you really can't pay the bill, let's work this out. As you saw in the debt settlement letter in the previous module, American Express had some pretty intense terms for that consumer, but the fact is that they made terms that the consumer could afford. American Express got its money, the consumer got to avoid bankruptcy. If you're willing to stand toe-to-toe with your bank and know that court is not a place where you will necessarily lose, you will certainly have your day and you may just prevail. I'm Harvey Z. Warren. This is Drop Debt.